The court will now call case number 126699, Jennifer Harding and Samantha Ramirez versus Capital Federal Savings Bank.
May it please the court, Kirsten Holseder for the petitioner, Appali Capital Federal Savings Bank. Pleased to be here today, and I would request 3 minutes for rebuttal.
3 minutes is granted. Thank you.
The key issue to discuss here today and reinforce in Kansas is that not all petitions present questions that warrant discovery or trial. This case involves one such petition. To try to avoid dismissal, plaintiffs ask the court to stretch the deference afforded under this state's notice pleading standard to an impermissible extreme. The Kansas rules permit a motion to dismiss for failure to state a claim before a defendant files a responsive pleading for a reason, and this case is an appropriate one for dismissal. The allegations that plaintiffs chose to include in their pleading in describing the fees that they dispute and addressing the notice provision, those allegations they chose to include demonstrate they cannot state a claim against Capital Federal. This argument will start by briefly discussing the location and contents of the notice provision at issue. Second, I will address the plaintiff's repeated contention that Capital Federal cannot, or that the notice provision cannot apply because in this litigation, Capital Federal has argued that the fees were permitted by the contract. Third, I will address the pleading standard, including plaintiffs' efforts to rely on their general allegation of compliance with the contract, even though they also alleged certain contractual obligations did not apply. Fourth, I will explain that the district court did not rely on materials outside of the petition. And fifth, I will emphasize why this contractual provision was unambiguous, why the terms improper charges cover the fees at issue in this case under the common understanding, which is even highlighted again by the allegations that plaintiffs chose to include in their petition. How they chose to define these fees in their petition is consistent with how they were defined in the account agreement.
You've listed a lot of things there. I guess I'm trying to figure out why we wouldn't jump to your number 6 and just figure out whether this section G says what you say it says or what they say it says.
Happy to do so. So I'm sure you're very familiar with the notice provision. It's located in a section of the account agreement that discusses deposits, charges to an account, including service charges, checks, items that cause overdrafts, and it also includes obligations of the account holder. Because having a bank account comes with obligations on the bank, but it also has responsibility for the account holder. And this includes an obligation to notify Capital Federal of certain disputes. The notice provision has a few categories of debits that trigger an account holder's notice obligation. The first one is errors or improper charges. Both phrases, errors or improper charges. It says account holders must review the account statements for errors or improper charges and then notify Capital Federal within 30 days of receiving their account statements.
Under this set of facts, that provision only serves a purpose of limiting Capital Federal's liability, right? You already know you're assessing these fees. So this is not, an alert kind of situation. This is simply saying, if I'm reading it, if you believe there's an improper charge or error, you're supposed to tell us, even if we know we're doing it, right?
So Capital Federal is assessing fees that it believes are proper under the account agreement. The notice obligation is so the account holder can tell Capital Federal, this is my understanding and why I believe this is improper. This provides an opportunity for Capital Federal to resolve that dispute, even if it disagrees. It provides Capital Federal an opportunity to explain to the account holder, this is what your agreement says, and by the way you are using your debit card and your bank account, you are incurring these fees because you do not have sufficient funds in your account. There are multiple opportunities that are presented by a consumer providing this notice. And the UCC in Kansas envisions this situation. Article 4 addresses certain types of transactions that automatically under the UCC a consumer must notify an institution within 1 year. And then the UCC says you can modify those elements by contract. So the UCC envisions there are benefits, not just to limiting a bank's liability, but there are benefits to a consumer timely reporting disputes to the bank so that it can, if there is an issue, it can be addressed, resolved, contracts changed, further explanation given to the account holder. It is not just about limiting liability.
So why don't you say that? I mean, that's my problem with this. I mean, it's almost like it got over lawyered because all you have to do is add the words, if you believe you've been assessed, a fee or a charge or an error that you dispute, let us know within 30 days. That's all it has to say. And it doesn't say that. You have to add those words to section G, right?
The section does not say if you believe. It does not have that exact phrase. However, the section is specific.
That's what the district court added to section G.
It was a reasonable construction of the terms to add that.
Regardless of that, it still gets added to it.
I agree that the terms if you believe were not in section G, but they are in there by how it is structured. It is an obligation of the account holder. It is talking to the account holder about what they must do. They must review their account statements. Whether an error or improper charge is asking them, if you believe, that's in there by nature of what it is describing, the obligation to review and then to notify. The final sentence of the notice obligation specifically references, if you fail to do this, you cannot file a claim about this. That envisions a situation where the institution and the consumer, after providing notice, don't agree that it's an error or an improper charge. And that is still the only instance when the consumer can file a claim.
And I don't mean to dominate this, but the term improper charge is only used in section G out of this, 51-page document or whatever it is.
I believe the phrase improper charge is only within that section. However, there are multiple places where fees, specifically overdraft fees and insufficient fund fees, are referred to as a type of charge. If you were to, charge is a broad term. It is any debit to an account. In order to follow the Court of Appeals decision that says, and that includes fees, you would also have to list, well, that also includes ACH transactions, check transactions. You would have to list every other type of charge. And the Kansas cases say, if you use a clear term, that is sufficient. Improper, something a consumer believes is wrongful, whether intentional or unintentional. If a consumer files a lawsuit, they must believe something is improper before they do that under the contract. And that's what these claims are based on. They're based on a contract. Under a contract, there are mutual obligations.
So can I ask a few questions along those lines?
Yes.
And assume for purposes of my question that your interpretation of the contract is correct. I agree with everything that you've said in terms of how we should read it. And that the consumer did have an obligation to provide the notice. I want to ask about the remedy, the second sentence, which says you're barred from bringing any claim. Do you have any case directly on point that approves of that remedy?
Based on a contractual provision?
Yeah, a 30-day notice that includes a remedy of you are barred from bringing any claim.
There was an insurance case in the briefing. It was I think it was Lyon, Lyon, that dealt with you had to give notice of the dispute within 30 days. And that ended up barring the recovery because they failed to do so.
Was that in the contract? Do you remember?
I don't remember if it was in the contract, but it was a condition precedent that they had to provide that notice within 30 days.
So a follow-up would be, what if the contract just said, you're barred from bringing any claim against us, period? There was no notice provision at all. The contract just said, you can't sue us.
So the contract's trying to waive all liability?
Yeah, are parties free to do that in Kansas?
I do not think they are free to do that.
So where do we draw the line? I mean, that's what I'm driving at. Like, what if it was a 1-day notice?
And this is not a 1-day notice. This is a 30-day notice where a consumer receives account statements every 30 days.
I understand, but I guess I'm looking for your perspective or insights to assist this court in where do we draw those lines? I mean, I presume, maybe I shouldn't presume, but for purposes of my question, I'll presume you can't write a contract that just says you can't sue us, period. And just because the parties signed on the dotted line, the law isn't going to necessarily recognize that because the law provides for causes of action. So where does the line get drawn in terms of you can't sue us? You know, a 1-day notice, 30 days. I can see the argument that, look, the customers also violated the contract. You might have a counterclaim for breach that includes its own measure of damages and so on. But why is it that the courthouse doors are just shut, just slammed shut? And when should parties be able to contract for that?
So there's the critical importance of the freedom of contract in Kansas. And 30 days has been upheld by this court in connection with insurance agreements that are also contracts of adhesion, company versus consumer. And so 30 days is a reasonable time period. I believe there are cases cited in the brief where 15 days was also approved. 30 days is appropriate here because that's the cadence at which they receive account statements. And they filed a breach of contract claim. That has requirements that they plead compliance with conditions precedent. This is a contract case. That was a condition. It's not just for a counterclaim. That's all my time unless the court has any questions.
Thank you. Mr. Seelan?
Thank you, Your Honor. Again, it's a privilege to be here before this court again. I want to respond to a couple of things that opposing counsel said. First, you said there are multiple references to fees as charges in the account agreement. I read through it last night and I only saw one. And there's no references to fees as charges in the paragraph of the account agreement that we have involved in this case, which looks something like this. And but that paragraph begins with this heading: reviewing statements, reviewing statements and error notification. So focusing the reader's attention on error. Then it wades through some prefatory, there are two prefatory paragraphs there, or one, I guess it's, yeah, about business accounts and about other instructions. And then says, except as noted in the electronic funds transfer disclosures as part 5, section H, or other document applicable to electronic funds transfers. And then we get to the point. If your account statement contains any errors or improper charges, you agree to notify us of any such errors or improper charges within 30 days of the date on which we mailed or otherwise made the affected statement available to you. But it doesn't stop there. It goes on and it says, if you do not notify us within that time, you are barred from bringing any action. And then it says, forged endorsements or alterations. It smushes those all together in one paragraph. And I want to contrast this one paragraph that contains, quote, errors or improper charges, and with forged signature or endorsement which is altered in any way, with the table that CapFed included in its supplemental brief with nice bold font headings and shaded blocks and borders, and the deletion of that distracting language that begins at the part of the operative sentence that we're dealing with here. If they had done this in this, I suspect we would not be here today, but they didn't do that. Instead, they compressed it all together in a situation where there are multiple references to fees elsewhere in the agreement, but none in this agreement. And the Court of Appeals correctly recognized it and said that when we look at the whole document, when we look at the use of other improper charges in context of the use of the term fees, and it appears nowhere in the paragraph with this notice provision, that's significant. It makes it unclear. Does it apply to fees? Does it apply to intentional charges that Capital Federal has never admitted in any sense are improper? They're their regular fees. They charge them routinely, telling them, hey, what about this fee isn't going to do anything? Capital Federal is just going to say, or let me go further. A reasonable inference from this document and from the briefing in this case is that Capital Federal would never change its position regarding its established fees. That's a reasonable inference. We're here at the pleading stage. Plaintiff needs to have the opportunity to pursue these claims and shouldn't be required to terminate them at the outset. Another point, Your Honor, is that these claims that Ms. Holtschuter referred to, described, these are not simple claims. I think the one thing that we agreed on in the briefing is that the Court of Appeals did a really good job of explaining these complex claims and how difficult they are to figure out. You can't look at your account statement and say, aha, you know, what they were doing is approving a transaction and allowing me to go through with it. And then later, because another transaction overdrew me, it caused an overdraft on the transaction that they had approved but were holding the funds for. You can't see that from the account statement. You know that if you are an expert in banking or banking law and understand that this is a problem that is nationwide. And the Court of Appeals recognized that. And the district court recognized these are valid claims. Claims of this type are valid. The district court, I think, made an error in piercing the only pleading that was before it, the amended petition, and engaging in judicial fact-finding to find out whether notice was or was not given, even though there was a general allegation that complies with our code. Then that brings me to another point. Failure to comply with the condition precedent is not listed among the affirmative defenses in paragraph, or again, 60-208C. But if you look at KSA 60-209, pleading special matters, it says conditions precedent. In pleading conditions precedent, it suffices to allege generally that all conditions precedent have occurred or have been performed. And I'll be honest, I have focused on that first sentence in KSA 60-208C until yesterday. And then I bothered to read the second sentence in 209C. But When denying that a condition precedent has occurred or been performed, a party must do so with particularity. And this means that even though it's not technically an affirmative defense, it is an issue as to which the party asserting it has the burden of pleading with particularity. And the other party does not have the burden of pleading with particularity, only has the burden of making a general allegation, which was made in this case. So I would suggest that Capital Federal has it exactly backwards when they suggest that it was up to the plaintiffs to lay out all kinds of facts about notice or attempted notice. Did they call, leave a message, and then hear back? Did they send something in the mail? We don't know that because that's here in this record, because that's outside the pleadings. The general averment is that those requirements were satisfied. And the only contrary thing in the record is the answer of my colleague, Mr. Khalil, to an unexpected question from the court. As far as you know, did they do anything to notify Capital Federal? And he answered candidly, as he could only do, and said, I don't know, not that I'm aware of. Not that I'm aware of. And it's on that posture that we find ourselves. That's the basis of the court's conclusion that the notice provision was not complied with. It's based on that fact finding. It's based on that fact investigation that the court engaged in that was precluded or should have been precluded by the first sentence of KSA 60-209C, that it suffices to allege generally that all conditions preceding have occurred or have been performed. And the inability of my colleague to give any further details, which again would have been beyond the face of the petition, was because that question was completely unexpected. And so as I stand here, I'm still perplexed that we're in this posture here today.
I don't want to spend much time on this, but I am struggling a little bit about whether we can even get to that that part that you're talking about. I know you've made the general argument, but do you have any thoughts about how it's been preserved for us to really get down to the particularity that you're talking about at this point? You think that falls within the generalness of the argument you've made?
If you ask about the statute?
Yes, about this.
Well, I think maybe the answer is in the Court of Appeals opinion, where the courts, I believe, held that the existence of a condition precedent is a question of fact, not of law. And it's not subject to a motion to dismiss. I suspect that perhaps that's what 209C may be dependent on. I've never read anything that says that specifically, but I think that that's what the Court of Appeals was thinking when it made that conclusion. And I point out that I don't believe that Capital Federal has appealed from that part of the Court of Appeals ruling. I believe that's undisturbed and it stands. And so that means that the questioning regarding conditions precedent involves questions of fact and therefore has no business.
Why wasn't that fact, quote unquote, admitted to in your amended petition, paragraphs 79 and 80?
Which fact?
That no notice was given. And the petition, I think, says in paragraph 79, plaintiffs had no duty to report the fees as errors. And in paragraph 80, any such reporting would have been futile. And that doesn't say the words, we did not give notice. But why can't the district court judge look at those two paragraphs and conclude they are admitting they did not give notice?
Your Honor, I think the problem with that is that the legal argument, well, first of all, let me just say, this is a class action. And in bringing a class action, which I've been doing for over 30 years, although mostly not in the commercial context, mostly in oil and gas cases. You always want to try to emphasize the broad arguments, the broad positions that are applicable to each and every class member. And so perhaps that skewed our focus in the brief. But the point is that making a legal argument of futility or unconscionability that would respond to this defense that the notice provision bars the claim is not inconsistent with the factual allegation in the complaint that the preconditions or conditions preceding were compliant.
You don't think the language, and I'm quoting directly from your petition, any such reporting would have been futile? I mean, the tense of the verb there is very clearly indicating that the reporting was not done.
Again, Your Honor, I disagree because this is a petition, a pleading on behalf of a class. We try to make the allegations as broad as possible so they cover everyone. I fully suggest to you that I'm sure there are people who had these charges and probably 99.9% of them never gave notice to Capital Federal. But that doesn't mean that our clients did not, and that does not mean that some others did not.
But before you're out of time, I wanted to give you a chance to respond to my line of questions to your opposing counsel. I understand your main argument focuses on the improper charges clause. You say it doesn't even apply to fees, et cetera. What about the second sentence, the remedy? You're barred from bringing a claim. Do you have any, are you making any argument about?
Yes, Your Honor, that I think is really at the heart of the unconscionability argument.
And I asked your opposing counsel for case law. Do you have case law that you're relying on that says that a 30-day notice requirement that has an included remedy that bars causes of action?
I believe we cited some cases where 30-day notice requirements were struck down. And I want to, I guess, and that reminds me of one additional point that I wanted to make, which is that there is a difference between a pre-suit notice requirement that says, hey, sometime before you file suit, you got to give us fair warning so we can figure it out and see what we can do about it. And this provision, which is really a legal remedy removal provision, because it says, hey, if you haven't told us about this complex legal deficiency defect in our standard fees within 30 days, then you lose your right to sue us. The counsel mentioned the 1-year statute of limitations. That applies only to in the UCC, that applies only to forgery and alteration. It doesn't apply to other charges.
Well, what's your best argument that this is unconscionable?
The best argument is that deprivation of remedy. That is the core. That is the fundamental unfairness that arises. The other arguments are what I alluded to earlier. You bury it in the middle of this agreement in one paragraph where you smush it in with forgery and alteration. And the title of the section says errors. It doesn't say anything about charges. It doesn't say anything about fees. So in other words, it wasn't clear if this is obviously their purpose, but the purpose wasn't clear in the face of the agreement. And it certainly wasn't conspicuous like that. Hey, if you don't do this, we're going to take your rights away.
So I'm sitting here emailing with my law clerks, and they checked the Lyon case that was referenced. And I believe that was a 60-day notice provision that was upheld. If this was 60 days, if this provision had said 60 days, would you still argue it was unconscionable?
I still would, Your Honor, because I think that taking away a remedy on that, I have clients come into me on a variety of matters, and they got a document in the mail. And well, by the time they got around to looking at it and pondering it and reading it, then they schedule an appointment with me 2 weeks later. I can't think of the time when it was within 30 days. I think that the court needs to be mindful that you are locking the doors to the courthouse if you uphold a provision like this. As a practical matter, I mean, if you gave me the account statement, I couldn't figure it out within 30 days because I don't have that banking law expertise. I'm just a litigator. So I think it's important that, particularly when you're talking about an issue that does not involve any third-party conduct, does not involve any unusual occurrence, and does not involve any need whatsoever to preserve or gather evidence, a notice period of this type for 30 days, for 60 days, for 90 days. I mean, why is it less than a year? Why is it less than 5 years? Why do the customers lose their right to hold Capital Federal accountable for taking fees that are deceptive and complicated, and that you need help to decipher? And I'll say, I couldn't decipher them myself.
Can I,
Yes, Your Honor.
let me understand your argument as to, based on the text, the textual analysis of the provision in question contains any errors or improper charges. Help me understand your argument to how we get ambiguity. It almost sounded to me like your argument was, hey, what is proper, what isn't proper is contextual, right? If we're at a tailgate, proper may mean something different than what we're doing here today. You know, what conduct is proper. And here we have an agreement. So that becomes the focus of how we test what is proper or improper. But I kind of lost you after that in your introduction.
I'm sorry, Your Honor. What the point I was trying to make is that we have cited cases holding that the word improper is inherently ambiguous.
Right. And I want to know why. I'm less concerned about the authority.
Okay.
But the textual analysis, where do we get to the ambiguity conclusion?
Again, because of the use of the phrase improper charges and the fact that fees are not referenced in the title of that paragraph, they're not referenced anywhere in that paragraph, but what is spilled out other than errors is forgeries and alterations.
So,
And for that reason, the meaning of improper charges is unclear. And
based on the reading of the agreement really as a whole is your argument and what's referenced in terms of.
correct. And I think Capital Federal's kind of come late to the game in terms of saying, well, you got to look at the whole argument. And over here, we called an NSF charge, an NSF fee charge. So that means that all fees are charged.
Is it fair to say that your argument actually focuses on the word charges, not on the word improper?
Well,
as I understand it, your argument is that the word charges is ambiguous because a charge could mean a charge that the consumer makes against his or her own account. They're spending money. Or it could mean a charge that the bank assesses against the consumer.
That's true.
For their services.
But I think improper further clouds the issue because improper is a vague term.
Okay.
And if there are no further questions, I'll sit down.
All right. Any further questions? See none. Thank you.
It pleased the court. And Your Honor, I did exactly what I would have had a nightmare that I did, and I remembered the wrong case when you asked me about that. It is the state insurance case that had a 30-day deadline. That case also involved a consumer or insured who tried to argue, well, in this case, you're arguing that you're no longer liable. You don't have to cover this. And the court said that defense did not negate your requirement under the contract to provide notice within 30 days.
But just real quick, what was the name of that case, the 30-day case?
I have it right here. I had it highlighted in blue. It just wasn't highlighted in blue in my head. It's State Insurance Company versus School District number 19.
Thank you.
My opponent was also focusing on the term charges and trying to look at the notice provision in isolation and saying that these fees are referred elsewhere in this contract as fees and not charges. Well, a very section right after the notice provision in I refers to them as overdraft and NSF charges. The fee schedule that they attached to their petition, which was part of the petition, admittedly can be considered on a motion to dismiss for failure to state a claim, repeatedly refers to these fees as charges.
Let me just, when you're talking about subsection H, I guess, as I went through this, it says charge you an NSF fee. And then it says charged an overdraft fee. So it's not used as a noun, but as a verb.
And then in section I, it is referred to in the last paragraph there, a schedule for the overdraft and NSF charges. So yes, it can be a verb and a noun. And just as plaintiffs do in their amended petition, they continually say both improper and improperly. They say the fees were charged. They also call the fees charges. Paragraph 78, which chose to discuss the notice provision, opens by saying the improper fees charged. They
That's a verb.
chose
Again, that's a verb.
elsewhere.
We're talking about a fee.
Elsewhere in the petition, though, they do refer to these fees as charges. Fees are a narrower category of charges. Charges have a broader meaning of any debit to your account, any debit initiated by the consumer, any debit initiated by a third party, any debit initiated by the bank.
That's your opinion, right?
Yes.
But that's not clearly set forth in this contract.
Charges say the common understanding is any debit. The agreement refers to them as charges. If the court doesn't have any other questions, that is my time.
I guess maybe what about proper though? The meaning of proper? I guess it's sort of like a circular question in a way, but if your position is the contract addresses fees, right, and overdraft fees specifically, is there an argument that because that concept is addressed, that it's not improper within the meaning of the notice provision?
So this contract does address fees, and I actually think including the word improper tells a consumer to say, if you believe any charge is wrongful under this, it violated the contract in some way. This is the consumer's obligation to notify the institution.
I know you're out of time, but I did think one more line of questions. And it kind of has to do with the intersection between the potential ambiguity in the word charges and the unconscionability potentially of the remedy. Because it would make sense to me to think that a consumer could be barred from bringing a claim when they don't give notice if the charge in question is essentially an unlawful draw on their account. I didn't spend that money. Somebody else spent it. I don't know how it happened, but it's an improper charge to my account. In other words, it's an improper withdrawal from my bank account. That makes sense that if you don't give notice, because the bank's innocent, I mean, presumably, if you don't give notice, you're going to be barred from seeking liability against us. When we think about it from a purpose perspective, it doesn't really make sense to require notice when the charging question is a cost imposed by the bank on the consumer for the bank's services. I mean, if that's improper, because then the bank's not innocent, right? If the plaintiff's substantive claim is correct, the bank is not, quote unquote, innocent. Can you talk a little bit about that? How the purpose of the notice might change depending on which kind of charge we're talking about?
Sure. And as far as unconscionability goes, before the district court, the argument was, well, this shortened the statute of limitations. That was the limit of the unconscionability argument. as held by the district court and is clear from the plain language, it does not shorten the statute of limitations. It imposes a contingent precedent. But to your question about whether there should be a distinction between the two based on public policy, I think it's important to also remember the public policy of freedom to contract, that undertaking this relationship to have your funds entrusted to the bank, especially to the extent where you're allowing your account to overdraw, you're spending more money than you have in your account. That's great
Sure.
responsibility.
And I'm sorry to interrupt, guys. One more question. I'm not thinking about public policy. I'm thinking about this in terms of resolving an ambiguity. And if this is ambiguous, there are two reasonable interpretations. If we look at the purpose, then that would seem to me to cut against the bank's argument, because the purpose, it makes sense in one interpretation and it makes less sense in the other. I just wanted to give you an opportunity to address that.
So there's also the purpose of discussing these issues with the bank so they can explain to you why a fee is assessed under the contract. So you can walk through this issue and change behavior in the future. And that's why it's on the consumer to notify the bank of anything that they believe in their account statement, because it's their obligation to review, is improper. It opens the door for this discussion so that consumers can change their behavior going forward as well.
Are there other questions?
Thank you.
Okay, thank you, counsel. Thank you to both counsel for your arguments. The court will take this matter under advisement.